Good morning, everyone. Can you hear me?
Yes, we can. Good morning.
Okay, wonderful, wonderful. Welcome aboard this phase of your trust experience. I hope the previous sessions have been enlightening and that I can add just a little bit more to all that crazy stuff you've been doing so far. Okay, I'm just going to try and share my screen, showing my contact information so that you can find me during the next couple of weeks if you need to. My name is Samuel Wilkinson, and I shall be shouting at you for the next 3 weeks, so to speak, and encouraging you to shout back at any time. Okay, let me just share the screen here first of all. Can you see my contact information?
Yes, I can.
Great. Please just take note of that, my email address, my cell number. I'll be available for you if you have any questions or issues throughout our session. And when we're done, if you have any questions or issues, I'll still be available. Feel free. Okay. Okay, did you guys get all of that?
Yes.
Okay, lovely.
Yes, thank you.
Okay, I'll just stop sharing here. So before I find out who I'm talking to this morning, do you have any questions about who you're talking to? Anyone? Remember, this is a feel-free class. You can say anything you want. Trust or no trust. Okay, if you think of anything along the way, please feel free. You can raise it anytime. That's the whole idea here, just for us to chit-chat and find out about what we need to find out. All right, let me see who I'm talking to then. My turn. I'm just going to go down the list that they gave me, starting with, is that Felicia Francis? Felicia, did I say that correctly?
Yes, good morning. It's Lisa.
Felicia, good morning. Introduce yourself to me, if not your colleagues already. Tell me who you are, why you're doing this course, anything you feel like.
All right, hi. My name is Lisa. Well, I'm just taking the course to understand the business better. I work at JP Morgan. Yeah. I'm not in the area, okay, but I want to learn more so I can move into the area. So it's to build knowledge and understand.
Absolutely, you're definitely doing the right thing, okay? If you're interested in doing trust, you'll pick up a lot of fundamentals, as I'm sure you'll see along the way by the time this whole thing is done. So when your trust officers are talking about things now they think you don't know, you will know. And yes. Sure, I encourage you, this is stage 1. I think the Institute has a stage 2. As soon as you can do it and present it to your people so that when the time comes, they can't say that you didn't take the initiative.
Yes.
Okay, so welcome aboard, Lisa. You're doing the absolute right thing. All right. Leah Lowe. Leah, can you introduce yourself?
Hi, good morning again. Leah Lowe, yes, I recently joined the trust administration company. Well, I shouldn't say recently, it's been over a year now. While I wasn't necessarily working directly with trust, it's something that I'm moving into. So I'm making sure that I can actually do it with some sense and the correct way.
Absolutely, absolutely. Nothing wrong with going in with quote unquote the right information, so to speak. We all know the real world is different from the academic world. However, as much as the real world tries to run away from the academic world, we still have to go back all too often to make sure we're doing it, like you say, the right way, which is a whole new world these days. The right way. My. All right, welcome aboard, Leo. You definitely are in the right place. Okay, who's next on my list? Is that Eronique Hepburn? Okay, Eronique is on the way. Melissa Sands, are you there?
I'm here.
Okay, Melissa, introduce yourself.
My name is Melissa Sands. I work at Scotiabank. The reason I'm taking the course is so that I can move into the area of wealth management.
Excellent, excellent. And it looks like the future of wealth management is in good hands. Okay, wonderful, Melissa. You are definitely in the right place as well. Last but not least, Janice Stubbs.
Hi, good morning, everyone. My name is Janice Stubbs. I work for an offshore family office on the accounting side. So I'm just trying to get a better understanding of the trust side.
Okay, excellent. You're also doing the right thing because oftentimes there's a conflict between persons in trust and accounting. And sometimes they seem to behave as if they're not connected. There's a little blah, blah, blah going on for some reason from time to time. But really, there's no adversarial situation at all. The accounting department should always be working closely with trust and vice versa, because that's how the whole process works, right? Your clients expect that you will prepare and provide the reporting on an accurate basis, and it has to be consistent with the requirements of the trust and so on. So it's an ongoing interrelationship that should always be encouraged. So you're definitely where you need to be, especially learning the language of trust officers, because sometimes trust officers can be interesting as well. Have you found that out yet, Janice?
Yes, so sometimes the way they understand things and the way we have to report things is different. So just want to make sure we're on the same page.
Absolutely, absolutely. Quite right, quite right. And I'm kind of happy you affirmed that for the persons who are looking to go into the trust and wealth management area. It just reminds them that they have only just begun, and they have a lot of interesting things to learn once they transition to trust and wealth management. All right, way to go. Okay, like I said, this class, for as far as I'm concerned, is an interactive class. You can ask questions about anything you wish, related to the trust that we're talking about, related to anything you've done, related to anything that may be going on in the world of work. You don't have to call any names to indict anybody, but you may have a situation that you may want to raise a question on, like, what about this situation? And whatever it is, I'm sure it'll be helpful to all the other persons in the room. All right, so don't be bashful, feel free. Okay, I'm assuming you guys all have your text already, and you know that this session will be units 6 through 9. Which means that over the next 3 weeks, we'll be looking at the duties and powers of the trustee, trustee remuneration, which is always interesting. How should trustees be paid, and should they be paid at all? And then, of course, the retirement and removal of trustees, which is another interesting aspect of the trust business. When should trustees retire? When should they be removed? Why? And then our final session will be around the responsibilities and role of what we call a trust administrator, which is that person in the trust company who heads it up and gets everybody, particularly the trustee, the trust officers and others themselves, to get the job done as required by the trust instrument, etc. So that's what we'll be looking at for the next couple of weeks. All right. Of course, as I said before, you can interrupt me at any time. I love interruptions because I always think that something interesting is going to come out. that can help everybody, okay, in the room. All right, so let's go on to Unit 6 then. By the way, what have you guys gathered in summary so far? Like in a nutshell, what do you think you've learned so far in this exercise for at this stage of the game? Anyone?
I don't know if I could sum it up very easily, but I do have a greater understanding of the relationship between settlor, trustee, and beneficiary. And I've been able to look through the Trustee Act with a greater understanding, as opposed to just a bunch of legal jargon that doesn't really tell you what it's actually governing to be done. So just in those first 5 units, I've learned a lot more, admittedly, than I thought I would have been able to grasp over just a few weeks.
Indeed, indeed. No apology for that summary. That's a pretty good one, actually. And really understanding the relationship between the settlors and the beneficiaries and protectors and so on is really quite fundamental to the whole trust process. Believe it or not, as long as trusts have been around for hundreds and hundreds of years, it keeps evolving. And so modern trustees are still grappling with trustee beneficiary protection issues. How far can the trustee go? How far can beneficiaries go? And so on. And so the battle rages on. And attorneys still continue to get richer and richer who deal with trust law because there's always some dispute, particularly in the modern trust world. In the old days, like 40 years ago, 50, 70 years ago, there wasn't too much dispute. The trustee was king. Whatever the trustee said was gospel. The beneficiaries pretty much sat back and received all the great benefits and monies and whatever it is that their parents or others left for them. But now beneficiaries are greedier. They're a little more cantankerous. They're always watching to see what the other beneficiaries getting, wanting to know who's getting more than whom and so on. And as a result of that, fighting is always going on. When accounting departments send information, in the old days, they didn't scrutinize it so much. They just trusted the accounting departments of the trust company. Now they're scrutinizing this modern group, this new generation of beneficiaries. They are reading stuff. They are more educated. They are greedier than their parents, they say. And they want to know everything that's going on. So they're challenging everything. So last year, it was $330,000, and now it's $320,000. What happened to the $10,000 difference? And they want to know everything about everything. If you can't answer, then they get their attorney and so on. If they find that another trustee's beneficiary getting more than them, they will get their lawyer and sue the trustee for anything they can think of until they are, quote unquote, satisfied that they are being treated, in their opinion, fairly. Okay? So you guys are doing in the trust world at a very interesting time when it's much more dynamic than it used to be, much more adversarial than it used to be. And the trustees and beneficiaries are much more at each other's throats than they used to be once upon a time. But don't let that scare you. That just makes it more interesting. So yeah, thank you for that, that bit of summary. That's very important to the whole process. And that's kind of the starting point anyway. Okay. Keywords like trustee, as you said, beneficiary, Trustee Act, and most importantly, let's not forget the trust instrument. Anybody remembers that document?
Yes, that's the document between the settlor and the trustee.
Indeed. And actually, it's a document that even some professional trustees still take for granted, believe it or not, in terms of administering the trust, especially if it's a legacy trust that's been with the trust company for a long time. Everybody get comfortable and they think they're following everything that's in the trust instrument, when in fact, until something significant happens and somebody, some hotshot lawyer picks it up and says, hey, My beneficiary told me that X is or is not happening, and according to this trustees, you are not following through, which in my humble opinion, this court suggests that, Mr. Trustee, you're in breach of trust. And then suddenly, something that the trustee thought was being done, it's not being done. Okay, so that trust instrument is a very important document. The only problem is sometimes we treat it like a marriage certificate. Once we get married, we put the certificate somewhere, never look at it again. We're busy being married. Okay, but for those of you who are thinking about becoming trust officers, etc., and who work in the environment already, let's not forget that document. That is the Bible for everything you do. It governs everything you do. It will make you or break you. When I say you, I mean the trustee, specifically the professional trustee, or any trustee for that matter. Okay? So those are just some words of wisdom as you go through this academic stuff. And this academic stuff is very important because it will also set the base in the background for you to understand all the practical things that you'll be doing in the real world. Also, it will help you to question some things if they let you question it in the real world about what's going on. Because sometimes when you get into the actual world of trust work, you might discover that some things are going on that are not consistent with what you learned. And so now you have to be the new kid on the block trying to raise a question. Like, according to my text, it shouldn't be this way. And they're like, the hell with your text? This is how we do it. Just do it. If you want to survive around here, sort of thing. So, just a few tidbits to reel you in on the exciting world of trust and wealth management that you are going into. All right, so Unit 6. What are the duties and the powers of the trustee? And the duties and powers are many. Okay, make no mistake about it. And as a trustee, by the way, you should have learned by now that there are two basic types of trustees. Anybody remember what the two are? We don't hear it a lot, but it's still very real. Remember the individual trustee and the professional trustee. Anybody ever said those two things? Anyone? Has anybody told you that yet?
I don't recall that.
Yeah. And it's okay. It's okay because a lot of times, even in the academic world, we don't reference those two things. We just assume a trustee is a trustee is a trustee, which is true, but there's a little extra truth to it. The extra truth is we do have two types of trustees. One is called the individual trustee, meaning individual persons like you and I. In case you didn't know it, if somebody comes to you, a family member or a friend, and says to you, I have a life insurance policy for $100,000 and I have two little children. I'd like for you to be my trustee. If in the event I die prematurely, that you will make sure that the money is made available to either look after my children or that they get it upon my death. If somebody comes to you and they do that, you in fact now become a trustee for that particular life insurance policy or any other assets that they might have. Okay? Should you have a trust agreement drawn up? You should. You should always have something of that nature put in writing, because word of mouth in a situation like that is not going to go very far. But once the agreement is drawn up and the document is in your hand, you're now the trustee. And her children or his children are the beneficiaries of that trust. And that's how individual trustees work. And we do still have quite a bit of individual trustees in the world. We just don't talk about them. Okay. Once upon a time, the other trustee, which is the professional trustee, which would be trust companies, we call them professional trustees because they have professional trust officers who are trained to do trust work. They have professional accountants who are trained to do professional trust accounting work. They have attorneys who are trained to give legal advice and so on. So these companies are considered to be, and they're incorporated entities. So they're considered to be professional trustees with a far greater responsibility to the legacies of millions and billions of dollars in which they are holding in trust for the beneficiaries of those trusts. Okay? So keep in mind that there are two types. They are out there. And any one of you in the room could easily become a trustee if somebody so desires and you so agree. Okay? That's the whole point. All right. So whether you're an individual trustee or a professional trustee, which most of you are or will be, there are lots of duties and powers that you will hold, and you have to hold them very carefully. A lot of times, trustees are so comfortable being a trustee that they start taking things for granted. It's like when you get married for a long time or in a relationship for a long time of any kind. After a while, like a couple of years, you start taking things for granted. Trustees do that. And therefore, they stop following through with the requirements in many cases of the trusteeship. Okay? And so these duties and powers of the trustee should always be reviewed as often as is necessary so that we don't take anything for granted. So we're going to be looking at the basic duties of the trustee. What do they do? What kinds of practical situations they run into as trustees. The trustee as a fiduciary, that's another interesting word. And also distinguishing between the powers and duties. For the purpose of trusteeships, powers and duties are not synonymous, meaning they are not the same. And we're going to find out the differences shortly. But before I go any further, there's another word that has come up that you need to be aware of as trust people. But we've already run into a whole lot of stuff in the last 5 minutes. It's crazy. This trust business is very, very interesting and dynamic, never ending. Okay, it's almost like collecting delinquent accounts. It's never a dull moment. All right, so what do you guys understand at this stage by the word fiduciary? Ever heard that one? Fiduciary. No?
Yes.
Yeah, what do you think that is? Who's a fiduciary?
I do believe the trustee. So that's the person who basically administers the trust.
Indeed.
Or the company.
Absolutely. And why are they considered fiduciaries? What does the fiduciary responsibility mean? It has a very specific meaning.
To act on behalf of another person?
Absolutely. In this case, the beneficiaries, yes. So yes. when you have a fiduciary responsibility, in the case of a trustee, it means that everything the trust company, trustee, trust administrator, everything they do must always be done in the best interest of the beneficiaries. Doesn't matter if you don't like them. Doesn't matter if you don't like the SEP law. Doesn't matter if you can't get along with the protector and all this stuff. Doesn't matter. You find your way through all that crazy stuff. And at the end of the day, your fiduciary responsibility to the beneficiaries is all that matters as far as the law is concerned in particular. Okay? Acting in good faith. That is a very serious word for any trustee. Remember now, when I say trustee, I'm talking about two types, individual or professional. There are a lot of individual trustees in the world that nobody talks about, but they're there. Acting as trustees on behalf of family members, friends, and so on. They're there. Okay, for sure. A lot of people do not go to professional trustees because their assets are not large enough to be a professional trustee, and all the cost of doing it will be, in some cases, eventually eat up the value of the assets, which is why a lot of times we have individual trustees who oftentimes will administer and act as trustee free because they know the person, they know the children, they know the beneficiaries, whatever the case might be. Or if there's a fee, the fee is a manageable fee. Okay, just keeping you minded of of those two things because they are very important. Okay. All right. So throughout the work of the trustee, whenever you guys become trustees, that fiduciary responsibility should always be in the back of your head, acting in good faith on behalf of your beneficiaries, no matter how big your trust company is. Because sometimes some trust companies are so big, multi-billion-dollar, like JP Morgan. Okay, who works at JP? JP Morgan. Lisa, yes? Yeah, a big old conglomerate with all kinds of things going on. So the trust department at JP Morgan is a monster. True or false, Lisa?
True.
Yeah. And sometimes monsters get out of control and they start ignoring important things, even that they're responsible for. Right? So it's something to keep, including fiduciary responsibility. How's that? But again, that's the politics, like working outside of fiduciary responsibility and doing all kinds of stuff outside of the ultra virus, the trust instrument, and all that stuff is oftentimes the political, personal side of this business. And that is not in your textbook. Remember, your textbook talks about what you ought to do. Once you get in the world, you'll be introduced to what is actually being done. And sometimes those two things are not the same. Right? So I don't envy you youngsters who are getting out there to get ready. I'm just putting you on notice. Do it. It's a very exciting area. And I promise you, you'll never have a dull moment. All right. So trustees are fiduciaries. Now you know what that's all about. All right. And your text tells you a fiduciary is one who acts on behalf of another. Okay. With regards to any matter, it doesn't have to be a formal trust company. Okay. If somebody gives you, tells you they're going away for a month and they'd like for you to look after their home, that is a fiduciary responsibility. You have to look after it in good faith. You wouldn't walk out the door and leave the door wide open, would you? You'd lock the door, yes? So that is a fiduciary responsibility. So this fiduciary thing kind of goes across the board. Okay? It has to do with trust. Okay? And so as fiduciaries, we are told that trustees have to maintain a position of trust and see that other word, confidence. Trust and confidence. And they didn't stop there. And there's a duty of loyalty. See, loyalty to beneficiaries. Now, notice there isn't any ambiguity in this language. Like, if you like a beneficiary, then you can be loyal. If you don't like a protector, then you can ignore other responsibilities to protect them. You cannot do that. The information is very clear. Your fiduciary responsibility demands that you be confidential. It demands confidence. It demands loyalty. And if you fail to do it as a trustee, you will find out eventually that the firm that you work for, and if you are one of the trustees, that you will be in breach. It's as simple as that. But I don't believe it. Well, that's okay. Like the Bible. I don't believe the Bible. That's okay. The Bible is still there. The trust instrument is the same thing. The trust responsibilities are the same. Doesn't matter if you believe or not, agree or not. That's the way it is. That's how crazy this thing is. Okay. For those of you, I hope by now you've been using or making some references to the Trustee Act. Please don't try to learn it by heart. The Trustee Act is just a reference point. You want to go through and see what's in it, how it comes to bear on any work that you do now or potentially, so that at least you have an idea of what governs trustee behavior in this jurisdiction, in the Trustee Act of the Bahamas. And so don't be shy to check it out and reference some of the material in there. Which brings me to my next point about referencing cases. I don't know if you've been looking at cases so far in the work that you've done, but it's always a good idea. Again, don't try, you may not necessarily read the case in its entirety, but you should at least have an idea. For example, the first case coming up is Bristol and West Building Society versus Matthew. You should check it just to see if the case actually says anything about fiduciary responsibility, duties, and loyalty. Okay. So just to familiarize yourself with the essence of the case, you don't need to learn all the details and get bogged down in the details of the cases. But it's certainly not a bad idea to reference the case.
Sorry, could you repeat the name of the case?
Bristol and West Building. It's right on page 1 of your notes under Unit 6 in the first paragraph. Okay. Bristol and West Building Society versus Matthew, 1996. Okay. So in terms of cases, even though that's 23 years ago or whatever, it's a fairly recent case because some cases go way back to the 18th and 17th century, believe it or not. All right, so do not be afraid to reference it. Again, at this stage of the game, you're not studying to become an attorney. You don't need to get bogged down in all the details, the legal mumbo jumbo at this stage. That's why they pay attorneys, but they pay them. Your job as a trustee is to be aware of the case and what it's trying to suggest, okay? To make sure it's consistent with your, in this case, trustee duties. Okay? Because right now we're looking firstly at the duties, and then later we'll talk about the powers. They are not the same.
I'm not seeing that.
Are you looking in Unit 6?
Mm-hmm. Appointment of trustees.
Your Unit 6 is appointment of trustees?
Yeah.
Which unit in your text says duties and responsibilities? So duties and powers.
It should be page 59.
Unit 7.
My page 59 is Unit 6, Duties and Powers of Trust.
Yeah, that's what it should be. That's
Oh, my page 59 is Unit 7.
My.
Oh.
Okay. So yeah. Different editions. Oh, got it. Okay.
So you said, okay, Bristol and West Building Society. Okay.
Yeah. Okay. Great. All right. So we're talking about trustee duties, and the first paragraph opens up with some very powerful stuff, and it opens up that way to arm you for what's coming after, and what you should remember forever as a trustee and working in the trust world. Okay, fiduciary responsibility, confidence, duty of loyalty. I cannot stress them too often because many trustees, even in practice, are oftentimes in breach of trust because of these very same mandates that they refuse to adhere to for one reason or another. Okay? Notice right in the second paragraph, we are told right away, a trustee has a standard of care. See, that's that fiduciary responsibility. Another case, okay? The Gone case of 1883. It'll tell you this standard of care. Now, you'd think that after the first paragraph, they'd stop talking about it, they made their point. But here we are in the second paragraph again, standard of care again. Fiduciary responsibilities come up again, okay? And then the case quotes, as a general rule, a trustee sufficiently discharges his duty if he takes in managing trust affairs all those precautions, which an ordinary prudent man, that's us, of business would take into managing the affairs of his own. So in essence, what are we saying here? As a duty, the trustee must understand that they're expected to carry out the affairs of the trust as they would carry out their own affairs with care and wisdom. Because the presumption is an ordinary prudent man would carry out his own personal affairs with prudence and wisdom because there's its own stuff on the line. And so the point we're making here, as a trustee, it may not be your assets, but the assets are in trust with you. That's where the word trustee comes from. We trust you to ensure that these assets are disbursed and managed the way we ask you to do it in the trust instrument. Wow. It's a big job already. that can easily be taken for granted because of the normal day-to-day work of doing the work. Again, it's like being, I like to use the married example because it's so synonymous in many cases. Sometimes when we get married or in relationships, we get so busy, we forget to stop and look at the mandate of being married. Or in, I want to relate, married. We get busy, work, children are up. We forget each other, like, what the hell? Didn't we get married? And people forget that. Trust, in the trust relationship, it happens that way too. We get so busy doing the trust work, we forget like our basic responsibility of care and fiduciary and loyalty and all that good stuff that we're supposed to be doing some other thing. Because like we grow to like one beneficiary or the other one, somebody is nicer than the other, whatever it is, and then we start moving away from the standard. Can't say I didn't tell you. Okay. All right. Notice at the very end of that last second paragraph, it says what? Does anybody see it? What's the last sentence in that paragraph? Anyone?
Highest standard care is required for a professional trustee.
Indeed. Why do you think that is so? If you're a professional trustee like JP Morgan or others, Scotiabank or others, why is there a higher standard of care than the individual trustee?
Because they have professionals working for them in the accounting area, the lawyers and so forth and so on.
Absolutely. They have professionals and professional trustees. Let's not forget that. Because that's where you guys are working towards becoming a professional trustee. Okay? One of these days, if you're really serious about the trust business, when you've done this, these 2 courses at the Institute, some of you will move on to do the STEP program, which you should do, which will take you on to becoming a professional trustee. Okay? Like any other professional, any other medical, accounting, or other professional. Because this stuff is serious stuff, just like any other profession. As a matter of fact, trustees are managing on a daily basis thousands, hundreds, millions, and billions of dollars. How about that? If that doesn't make the point, what does? So the professional trustee is just as critical as any other professional in the world. So that higher standard, you have more education, you have more resources, trustee, Mr. Trustee Company, and therefore we are not interested, particularly if it gets to court, because it's the court that puts this higher standard on professional trustees in the first place. Don't come to this court with fly-by-night stuff. You have a greater responsibility. Don't blame whoever you want to blame. You are the professional. Just like the lawyer and the doctor and the accountant. You are the professional. And therefore, you are expected to behave better than the non-professional. Doesn't matter if you agree with that or not. That's just the way it is. That's what highest standard of care is required of a professional, trustee or otherwise. All right. So what are the 2 basic types of trusts, by the way, ladies, that we have out there in the trust world? Do you know? Remember? One of them starts with a D. 2 basic types of trusts.
Say it starts with.
Say it again?
Say it starts with.
Say it again, sorry.
I was asking you, what did you say it starts with? A D?
Oh, D, yes.
Discretionary?
Yes, doggone it. And the other one? It has a little word in front of it.
Non-discretionary.
Non-discretionary.
Yes, yes, yes. Discretionary and non-discretionary. Just as critical a set of terms as all the others have said so far, like fiduciary and standard of care. Men, these are the core things that make trusts work and that keep you out of getting into trouble as a trustee, as long as you keep them in the forefront of your mind. except there's still many even professional trustees who don't adhere to these rules. That's what is amazing. Just like money laundering. A lot of major banks are fined millions of dollars a year for violating money laundering rules. And yet, and anon, like Shakespeare would say, they still go back the next bloody year and try to get away with it. Trustees do the same thing. They know what the rules are. And still, my. Again, you can see some of these things are not in the text. That's just me talking from experience, because experience is a very serious thing, which you will find out when you guys jump in, okay? And do jump in. Like I said, this is a great paying job, but it's not all about the money. The job is very dynamic, and there's never a dull moment. So despite all the blah, 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 I'm still encouraging you, jump the heck in. Wholesale, see what happens. All right. So yeah, this trustee business is serious business. There are discretionary trustees, trusts, and non-discretionary trusts. Anybody knows the difference?
Non-discretionary trusts are very specific in what can and can't be done, and discretionary trusts leave the decision-making up to the trustees.
Indeed. Couldn't have said it better myself. Precisely that. So if you're a trustee and you're given a non-discretionary trust, it means your opinion doesn't matter. Your professional experience doesn't matter. Your morality about whether it's right or wrong is irrelevant. Non-discretionary means you have no discretion. The only thing that you've signed up for in a non-discretionary trust is to do exactly as the instrument says. Nothing more, nothing less. Sorry. However, if you have a discretionary trust in your portfolio, then you can use your experience and your professional expertise to make decisions about what should happen. For example, if you have the discretion to do it, you can decide which beneficiaries will be paid what amounts out of the fund. That often leads to a lot of trouble for trustees, but that's what discretion gives you. Some beneficiaries are gamblers. So the trustee might decide for the gambler, they're going to waste the money. We'll just allocate this amount. Some beneficiaries are responsible, so they'll allocate a higher amount. Some beneficiaries are disabled, so they'll allocate an even higher amount. Some beneficiaries need mental attention regularly or intermittently, and so they'll allocate accordingly. See, that's how it works in a discretionary trust. If it's a non-discretionary trust and they said, I leave nothing to my husband, he's a bastard, doesn't matter if you agree. Sorry, he may not be a bastard, might be a nice guy, she just wouldn't leave it. Or vice versa. Okay? Welcome to the real side of the trust. Okay? There's a human side to the trust business, by the way. And you all, if you haven't discovered it already, you'll find out it's very interesting side. But that's what it's all about. It's all about managing the assets of the settlor. I'm sure you know by now that once the settlor has turned his assets over to the trust company or the trustee, he cannot get them back. Are you aware of that? Anyone? Are you aware of that? Is that a yes or a no?
Yes, sorry.
Can the settlor get his assets back after turning them over to the trustee?
No.
No. No. That's why there aren't too many trusts in countries like Brazil and certain parts of Europe because they don't trust the trust process. Does everybody get that? Even though in the Western world, trusteeships are very common. In countries like Brazil and Spain and those kinds of countries, Argentina, South American countries, certain European countries, certain African countries, certain Asian countries, certain Indian countries, and so on, Middle Eastern, they don't believe in trust because they don't want to turn their assets over to anyone. They don't trust it. That means once they've turned it over, they no longer have control. It's out of your hands. And if you thought you made a mistake, it's too late. And if you have a gripe about it, then you can take it to court, and the court will decide whether you get it back. In most cases, they won't, unless you can give a very good reason. So the trustee's main job is to manage the trust assets and to distribute those assets in accordance with the trust instrument. That's your main job. Everything else is secondary. Okay? We are told that these duties are typically owed to the beneficiaries, and any trustee who breaches the trust instrument will be in breach of trust and therefore can easily be sued. And sometimes they lose and have to pay the beneficiary or whoever's bringing suit against the trust. And sometimes millions of dollars because of breach of trust, because somebody didn't follow through with the requirements of the instrument or the duty of care. Misuse the power, see? Remember we're talking in this first phase about trustee duties. Power is a different thing. We'll see that later. So you could misuse the duty and misuse the trustee powers. Either way, you can end up in court, potentially paying millions of dollars, losing the money, millions of dollars as you earn in income from that trust, et cetera, et cetera. Okay? Very serious stuff. All right. So then, notice in this third paragraph, we're not even off page 1 yet, and there's just so much power-packed stuff about the trustee responsibility, and there's a reason for that. These are foundational issues, these trustee duties. And the better you understand the duties, the more successful you'll be as a trustee and even a trust officer, by the way, in getting the job done. So these duties are owed to the beneficiaries, and breaches can lead to suits, etc. Improper or negligent performances of trustee duties could result in legal action or liability being brought against the trustee. So always keep in mind when you're doing your job what your responsibilities are. If you're not sure, find out. And this goes for any trustee and trust officers and all others connected to the trust, to make sure that they're doing their jobs, including trust accountants, by the way. Because some trust accountants don't feel like they have any connection or obligation to certain trust responsibilities, but they do. Trust reporting and accounting and financials and so on have to take a certain format, has to be correct, has to be clear, has to be explained, and so on, so that beneficiaries understand what it is. And remember, the beneficiaries now are looking at financial statements, and anything that they don't understand that might be tucked away somewhere or put in language that they don't understand, they're going to ask. And if they can't get a clear explanation, they might sue for an explanation. Okay? So even the accountants and who are not trustees have to themselves be governed accordingly or be brought into question. Beneficiaries have changed. All right, so we are told that these trustee duties can then be divided into 3 broad categories. Okay? The first one has to do with management responsibilities, such as the responsibility for investing the assets of the trust, for managing the day-to-day affairs of the trust, and certainly for distributing trust properly, reasonably. Please watch these adverbs: reasonably, fairly, prudently, and equitably or equally. Very serious stuff. Whether you get it at this stage of the game or not, and just imposing it on you so that when you get into the blah, 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 it's, oh my God. Okay? These are very serious things. See? Notice all the stuff that came after distribution of trust property. And one of the reasons why it is said that way is because even today, as we speak, there are many trustees, professional trustees nonetheless, who are not distributing trust assets and property according to these adverbs. Some of them are still today distributing trust property unreasonably, believe it or not, unfairly, imprudently, and unequitably, believe it or not. If you check the record, there are lawsuits every day somewhere in the world against trustees who are not adhering to these management duties for one reason or another. All right. Second trustee duty, administrative responsibilities. You must carry out all of the terms of the trust, students, when you get into the trust world. If you're not sure, check. If your supervisor tells you you're not comfortable, check. Ask another supervisor, ask somebody else. Especially if you're dealing with a particular account or client or portfolio. Okay? Make sure those administrative duties are consistent with the terms of the trust, not what somebody tells you necessarily or what you feel. Make sure they're consistent. Otherwise, you could find yourself and put your company in jeopardy. Okay? And then the third duty of the trustee is the duty of proprietary. Trustees must not act dishonestly. What can I say? Seems pretty straightforward, but there's a reason why we should be able to assume. But when the text is not assuming it, no text in trust assumes it. We must not act dishonestly and inappropriately. We must not. With regards to any beneficiary. Doesn't matter if you like them or not. Believe it or not, some beneficiaries have personal relationships with trustees and trust officers and all this stuff in the real world. And that's why this is here. Be careful. Doesn't lead to impropriety behavior. Always communicate with beneficiaries in a what? Anyone? Always communicate with beneficiaries in a what? Anyone?
Professional and timely manner.
My. What can I say? All I can say is you don't have to follow that directive, but I tell you, if you don't, you'll find yourself in a lot of hot water as a trustee, trust officer, trust accountant, whatever the case might be. Okay? Timely. Modern beneficiaries do not like unnecessary delays. It pisses them off, especially if they are moody, cantankerous, or some such person. There are some beneficiaries that are like some people. Okay, whenever you get to it, I'll be here, waiting patiently. Thank you. But I can assure you, not all beneficiaries are that way. Some of them are very cantankerous. If you take too long, they will go to the top of the organization and report you. And if that particular beneficiary is the beneficiary of a major trust, that can cause a lot of problems for people down the line. Okay? All right. Have I yapped enough already? Okay. I'll yap a little bit more and then I'll ask somebody to join me in the yapping. So, we are told that one of the primary duties of a trustee in its administration is to act in good faith. See, back to that again. Reminder of fiduciary responsibility, and certainly in the best interest of the trust, period. It has nothing to do with you, how you feel. And the reason why it's there is because trustees sometimes still act according to how they feel and what they want to do, interestingly enough, even though the rules are clear. The trustee's interests are of no concern. What is of concern is the interest of the trust. But I don't agree with it. Doesn't matter what you agree with. You only have that option maybe if you have a discretionary trust. And even then, you have to be careful how your personal and professional ideas get wrapped up even in your discretion. Because if a beneficiary feels that your discretion is lacking discretion as appropriate, they will still bring the heat on your trusteeship. Okay? And remember, one of the problems with having problems with beneficiaries is that enough beneficiaries can get together and sue you, cost your company, your bank, your institution tons of money, and worse still, cause you the loss of that legacy trust. And sometimes, like I said, trusts are a multi-million, multi-billion-dollar trust. You don't want to lose them. Every year you earn millions of dollars in trust income. So you don't want a little itsy-bitsy violation or an unsettled beneficiary to cause you to potentially lose your entire account. Okay? Wow. Sometimes trustees find themselves in a position where their duty conflicts with their personal interests. Okay, students? When you get on to doing stage 2, you'll see these things again, plus more. And if you decide to go on and do even higher level professional trustee learning, you'll see these things again and more. Because the fundamentals don't ever go away. It's like the ABCs of what we do. And these things that I've mentioned so far, the ABCs of what we do. Okay? So it's something to keep in mind as you go forward. Okay? The duties of the trustee can and often do conflict with your personal interests. Should a trustee's duty conflict with his personal interests, he will be liable to the beneficiaries. And if he benefits in profits or gain of any kind, this could and often does result in a conflict. So if you're a trustee or trust officer, for example, and because of your knowledge of what's going on in that trust, you set up a company of your own and start making money because as a result of that and result of the information you have, that is a conflict of interest. And if a beneficiary finds out, they might not be happy about that. Okay? Ray versus Ford, check it out. Try to keep your personal affairs out of your business affairs. Try to keep the conflict of interest issues to a minimum, if at all. Because at the end of the day, it can cause a lot of problems. Notice the next paragraph is very clear. It does not matter how honestly the trustee acted, in good faith or otherwise. If he is found to have acted in conflict of his duties to his responsibility of the trust, it's going to be a problem. Okay? There are some exceptions. If the trustee wants to do something and he feels it's going to create a conflict with the beneficiaries, he can then call a meeting of the beneficiaries and have a discussion and say, hey, are you guys happy with this or not? If they say, yeah, that's fine, we're good with that, then he might be able to proceed. If they say, we don't think so, that's going to be a direct conflict or an indirect conflict. We just are not happy with that. And the trustee should be guided accordingly. Okay? Wow. Notice if the trustee is given this duty and this conflict occurs as a result of this relationship with the settlor, perhaps, maybe some other consideration might be taken into account. But generally speaking, we should avoid conflicts of interest, not only in trusteeships, but in other stuff that we do in our personal lives as well and other involvements. Try to avoid issues that are going to create conflict of interest. If you sit on a board and you start doing business that conflicts with what your board's company is doing, then that's a conflict of interest. Happens all the time. Okay? A lot of people use proprietary information from boards and trusteeships and all this kind of stuff to do other personal stuff that conflicts with those particular institutions. And they know they shouldn't. But of course, money is a very powerful persuader. All right, so yeah, check out Sergeant and Another versus National Westminster. You'll see that it tells you about this particular part of the trustee's responsibility. In particular, conflict of interest issues. Try to avoid them. In fact, we should try to avoid them outside of trust, because conflict of interest issues are always stinky, no matter what it is. Even in, can we have conflict of interest issues in church? Anyone? Can we? In churches,
I think so.
Yeah, conflict of interest issues can arise just about anywhere. Okay, so beware. It's not just a trustee issue. It can arise anywhere. All right. Now, having said all of that, we have another laundry list of stuff. Man, when does the trustee get a break? You don't. Because fiduciary responsibility doesn't give you any breaks. Just a bunch of rules that adhere to, so that you don't take the trusteeship for granted. And guess what? Some trustees all over the world still do, individual and professional. Despite all the rules, just like the rules of money laundering, still people still trying to launder money and still doing it successfully too, for one reason or another. Okay? So those of you who are going into this world, welcome to an exciting world of this and that. All right. So after all that, you have 10 more duties listed. Does everybody see those 10? You think after all that, before that, that would be so great, fine, good, let's go on. No, hell no. 10 more duties. And notice that it doesn't say that the trustee could. It doesn't say the trustee might. It says the trustees what? Anyone?
Must.
Must. No choice. Now, you're going to get out in the real world where people can start making you think sometimes that you have a choice as a trustee, but you don't. If you try to assume you have a choice, then you could find yourself in breach of trust for all the previous reasons now plus these 10. Okay? Trustees must, 1, become familiar with the terms of the trust. I cannot emphasize that anymore. I'd lose my voice and my mind trying to do it. All I can say is the trust document governs everything, whether it's discretionary or non-discretionary. Stay in touch with it. Make sure you're doing the right thing. If you don't, you'll find yourself in breach of trust eventually. Administer the trust, number 2, in accordance with all its terms. Not your own thing that you want to add into on a particular day because you feel like doing something special for a beneficiary. Can't do that. Or otherwise. Can't. Treat, see number 3? Treat all beneficiaries fairly and impartially. Don't get personally involved with beneficiaries. Happens all the time. Some trustees and beneficiaries are actually drinking buddies. They go out together, they go on vacations. Because some trustees feel that if they can influence certain beneficiaries who can influence other things, that they can get other benefits from the beneficiary outside of the trust responsibility. That's why it's number 3 is there. If you have a discretionary trust, if you don't like a beneficiary, you still have to treat them fairly and partially, just like you treat all the others. If you have a beneficiary that's a little mean to you, every time that you have a beneficiary meeting, they tell you, go to hell, you're a dog, you're not doing a great job. You still have to be fair and impartial towards them. You cannot take it personally. Especially if you have a discretionary trust that you're managing. Because sooner or later, they'll figure it out and they're coming after the trust. With a good lawyer too. Maybe a QC even. Okay. Anybody know what QC is? Anybody? Any trust officer or potential one? Who's a QC in law? Ever heard that word before? That acronym?
Queen's Counsel.
Yeah, Queen's Counsel. What's so special about a QC?
They the boss.
Well, okay, that's good. I like that. Yeah, in a way, they're the bosses of their profession. How's that? Okay? They're not the boss of anybody else unless they have their own firm, but they're the bosses of their profession. In other words, when you become a Queen's Counsel in Commonwealth countries, like the Bahamas and the other, Canada and other, India and other Commonwealth countries that still exist, which excludes Barbados now, correct? Correct, folks? You know that Barbados is no longer a Commonwealth country.
Didn't even remember that.
Mm-hmm. And that's okay because Barbados only recently became a republic a couple of weeks ago. They've given up the Queen as head of state. So if you were not aware of that, there you go. Okay? I think Jamaica is another country. Guyana might be as well. Trinidad might be as well. So those countries that were former Commonwealth countries, like the Bahamas, like Cuba, like Canada, like India and others, who still Commonwealth countries, Barbados has just recently given up her status as a Commonwealth country. The Queen is no longer head of Barbados. Barbados is now a republic like the United States, and they can therefore now do whatever they feel like. So they won't be giving out any more QCs, and if they do, they won't be calling it QCs. Perhaps they'll be calling it their own thing. But for Commonwealth countries, when you become a QC, it means that you've reached the pinnacle of your legal profession, and therefore you are a respected, knowledgeable, and experienced advocate who has been there, done that, and who can charge the big bucks for the big cases that come up for their clients. Okay? So I just kind of threw that out. If a beneficiary decides to sue the trustee and they come with a QC, that could be a big problem. What about number 4? What is our duty? We have a trust accountant in the room. What is for number 4?
Number 4 is to make sure that they receive copies of their financials and know what their investments are in details.
Absolutely. Whether you believe it or not, a lot of trustees don't do that properly. A lot of trustees don't do it on a timely basis. And oftentimes, number 4 is a big problem for even many professional trustees. Okay? Giving a proper accounting of the trust funds through financial statements or similar, and providing portfolios to beneficiaries for trust investments. Don't assume that all professional trustees do this well. They all do not do it well. Oftentimes, there are hiccups across the board. And part of the day-to-day madness is trying to get it sorted out. Okay? Number 5, invest trust properly, see, in a timely and authorized manner. You cannot invest it how you feel like. You have to invest it according to the instrument, or if it's discretionary, you have to use your best possible discretion. And sometimes, or most times, that means getting investment managers, because trustees are not investment professionals. They now have to outsource it to investment managers. And if they discover trying to do it themselves, they can be sued, because then the QC will say the trustee is not trained to do this investment job. And therefore he was acting imprudently, unwisely in trying to do it himself. See? And so this mandate or this duty is to protect the trust and make sure that trust properly is always managed in a timely and authorized manner. If a trustee shows up in any particular year and said, well, we didn't invest any of the cash because we didn't want to take a risk, a beneficiary could sue and say you should have taken a reasonable risk. And sometimes they've won. But the trustee said, well, I don't want to take the chance. I said, well, you should have. because we don't want you to take great risk, but we want you to take reasonable risk in order to what? Increase the value of the assets. So all of a sudden, this trustee thing involves all kinds of crazy stuff. And notice these duties are not might, these are must. You have to do them, right? Number 6, protect and preserve the trust property. See, protect and preserve, like the police. Protect and preserve. And you really like police because you're policing the trust. And if you're policing anything, a big part of policing is protecting and preserving. So you cannot actually take the trust property that's in your care and deal with it in what we call a helter-skelter manner. If your trust property started out at 10 million and 3 years later it's down to 5 million, you're going to be in trouble because you're going to have to explain why the hell the assets went down instead of up. Okay, that's what that means. Okay? Preserve, protect, and preserve. Part of their fiduciary responsibility. Well, what about number 7? A lot of trustees don't like number 7. And some still even try to avoid it, and then beneficiaries get mad and report them to the board, to the CEO, like, where the hell is my information? We have a multi-million-dollar trust with you. You want me to take it and go somewhere else, Mr. CEO? So beneficiaries have to be kept informed, okay, in accordance with the instrument and in accordance with the law. How about that? So now we have another player. The first player was the trust instrument that tells you exactly what you should do. The other player is now the law. Because whenever the trust instrument fails or there's no agreement on it or disagreement on it, it then goes to the courts. And what you should know by now is that whatever the court decides is final, whether you like it or not. Okay. Number 8, we talked about it, conflict of interest. Do not make personal profit from being a trustee unless it is authorized, either in the trust instrument, banned by the beneficiaries, or by the court. So you could make a personal profit potentially, but you shouldn't do it unilaterally on your own. If you're going to do it, if you would like to do it, if you have a desire to make personal profit from trustee profits or trustee assets or business, or you have knowledge of what's going on, you can consider it. But before you do it, pick up the trust instrument and see if it authorizes you to do it. If it doesn't, then you can go to the beneficiaries and say, hey, the trusteeship would like to do this and there'll be some profits coming out of it as a result. Are you happy with that or not? If they say yes, then fine, do it. If they say no, then don't do it. Now, some trustees are so adamant about their personal profit motives that even if the instrument or the beneficiaries are not happy, they might decide to go to court anyway and see if they can get the court to agree with them. That's a bit of an extreme situation to generate personal profit. But again, if the personal profits are significant enough, it will drive people to do just about anything they think they need to do. Beneficiaries or no beneficiaries, courts or no courts. All right. Number 9, do not delegate your duties to anybody unless the instrument authorizes you. Your responsibilities and your duties as a trustee are yours and yours alone. Do not try to pass it on to the investment manager, some legal department, some other outsourcing area. It's yours and yours alone. Now you can hire people to do certain work, but you still have to take responsibility at the end of the day for whatever is done as a trustee. And then last but not least, act wisely again. See, prudently in the administration of the trust. I don't suspect there's an accident that was the last one, and certainly not the least one. Okay, I suspect at this stage it's just a reminder of everything that's already been said before. All right. So on that note, Consider the case of Boardman versus Phipps, 1967, which we are told illustrates the importance of making secret profits, eh? A lot of reasons why people like to sit on boards is because boards give them information so they can make secret profits. Trustees are no different. But trustees have a duty that is even higher than board members who also have a duty and a care, okay? Because board members are like trustees anyway. They are the trustees of the companies and entities they represent. Though some of them don't seem to think so, based on some of the things they do. All right. So yeah, you can make secret profits, but you have to get authorization. That's one of the rules we saw earlier. And so this case, when you have a look at the essence of it, that just kind of goes into a little discussion coming from the judge in this particular case. And notice his comments are in inverted commas, which means it's a quote. And notice how this quote opens, students. No person, see? No person standing in a what? Fiduciary position. We already talked about fiduciary. It's come up again. It'll always come up. It's part of the foundation of trusteeship. Fiduciary, remember, has to do with good faith behavior. When people give us their money, that's a fiduciary responsibility. We have to take care of it. When we, in relationships, that's a fiduciary responsibility. We act responsibly. When we have children, we have a fiduciary responsibility to them. It's everywhere, not just trustees. That's how deep the trustee program, trusteeship issues are, okay? No person standing in fiduciary responsibility, whether when a demand is made upon him by the person to whom he stands in a fiduciary relationship to account for profit acquired by him by reason of the opportunity being a trustee through the knowledge or other resulting from that relationship, is entitled to defeat the claim on any ground except that he made those profits with the knowledge and assent of the other person. Very clear, even as Old English, even the Old English on not making secret profits are clear. It's a very big issue because secret profits can be in the millions of dollars, and sometimes it's in direct conflict with the trustee responsibility that you are responsible for. That's why we make a big deal out of it. Okay? Notice, profits may be in the form of directors' fees. How about that? They have to be authorized. They're not automatic. Okay? That's the point. If a trustee enters into competition with a company that is owned by the trust, that is a conflict. IDC versus Cooley will tell you. Or the misuse of any opportunities and information. So if you have information as a board level, a trustee sitting on a company under the trust on the board, and whatever it is, if you're making any profits based on that relationship, you could be in conflict of interest. Okay? My. Trusteeship is a big responsibility. Even if you're not working in a professional trustee environment, any responsibility of trust, that's the whole point. Any responsibility of trust. It reminds me one time ago when one of my sons was little and he wanted something, and like, so dad does not have the cash at the moment. He said, okay, Dad, why don't you just use your card? So as far as he was concerned, he had no idea, no concern about how the card works, that you have to pay it back, you have to pay it, none of that stuff. Okay, he's just a child, innocent. And so as father, I have to be responsible for even that failure and all the others. Trusteeship is a serious business, as you guys will see. All right. That's enough yapping from me for the moment. So, what page are we on now? Are we on the page that says the trustee may not?
Yes.
Okay, wonderful. So I'm going to ask Miss J.P. Morgan, since she's already in a trust environment, because by the way, among many other things, J.P. Morgan is a major trustee of trusts. Okay. So, and has been providing trust services in the Bahamas since some persons were born, maybe even in this room. All right, so they've been around a long time. So, Elisa, since you are in that auspicious environment, why don't you pick it up, beginning with the trustee may?
Okay. A trustee may not delegate his duties to an agent, third party, or co-trustee unless his is authorized to do so in the trust instrument. In order to delegate such duties, the trustee must ensure that there are provisions made in the trust instrument to allow him to appoint agents and delegate tasks for the administration of the trust. In common law, the case of Steele versus Welcome Custodian Trustees Limited, 1988, confirmed that a trustee will be given immunity or protection under law for the delegation of his duties to an agent. However, under the Trustee Act 1998, the trustee must take reasonable steps in the appointment of such agents and in the supervision of their delegated tasks. It is important to note that only in exceptional circumstances may a fiduciary receive remuneration for his time and effort in acting in such capacity. As a general rule, trustees are not allowed to be remunerated for their work in relation to the trust unless they are authorized by the trust instrument. Therefore, trustees must ensure that the trust instrument allows them to be remuneration from the trust fund for reasonable expenses. Example, out-of-pocket expenses incurred in the administration of the trust. The court does have discretion to allow remuneration or increase a trustee's remuneration. Case Foster versus Spencer, 1996, and Reduke of Norfolk Settlement Trust, 1982.
Thank you. Stick a pin for a moment. Just stick a pin for a moment. I just want to say something, Lisa. Notice what she said earlier. Two key things. One, a trustee may not delegate his duties to an agent or a third party. You can hire an investment manager, you can hire a lawyer, you can hire an accounting firm, you can outsource, get an agent for any of these things and pay them for their professional work and providing you as trustee with the information you need. However, at the end of the day, you cannot blame them for anything that goes wrong. You as the trustee are ultimately responsible. Now, if something comes up and they mess up, the trustee takes responsibility first, and then the trustee may sue the agent. But as far as the beneficiaries and the courts are concerned, the trustee is first liable for whatever goes wrong. So you can delegate the work, but you cannot delegate the responsibility. So if you get an agent of any kind to do any work for the trust, you must follow the agent, get information, find out what they're doing, question them, raise issues, fire them if necessary, whatever you need to do, okay? Because your responsibility as a trustee remains, okay? All they're doing is using their professional skills to assist you in getting your job done as trustee. So if you have a $10 million portfolio, clearly you're not an investment manager. So you will hire an agent or an investment manager or managers to manage your portfolio, hoping that they will invest the money in areas that will bring a return that will add to the trust investment portfolio and not reduce it, if possible, okay? But in any event, while they're doing their professional work, you as trustee, your job is to monitor them, get information, get feedback, make sure that they're doing things correctly. If you notice in your monitoring that the investments are losing money, to go back and say, why is it losing money? And the explanation is not reasonable, to stop the investing manager or managers from managing those accounts and maybe find someone else, or redirect their investment program So maybe you should be looking at some other types of investments. These are too risky. Let's do some more conservative stuff. So that is key. You can delegate your responsibility, but you're ultimately responsible. It's like working in a company. The CEO can delegate responsibility to the professional and other staff in the organization. But at the end of the day, when push comes to shove, the CEO is ultimately responsible. The Prime Minister of the Bahamas can delegate responsibility from the ministers all the way down, directors and heads of all the way down to the janitor. But at the end of the day, he or she is responsible for the country. And that's just the way it works. Okay? So we can delegate it, but the ultimate responsibility, if we're ahead of it, remains with us. The trustee is no different. Okay? The other thing of interest, trustees cannot and are not allowed to pay themselves just because they worked. The way trusts work, if you wish to be paid, you have to get authorization to do it. If you're a professional trustee, you should make sure before you take on the trust that the payment is in the trust instrument. If you take a trust instrument that does not have payment terms, then you will not necessarily be paid for your work. So most professional trustees, if not all of them, they know when they're negotiating taking on a trust, they look at the instrument, make sure that payment is included so that they can be paid the millions that they're paid, thousands for whatever work they do on behalf of the trust. If you're an individual trustee, if you wish to be paid for your work, you have to get approval in the trust instrument that your pay will be X amount per annum for managing the trust, even as an individual trustee. Okay? So payment to trustees are not automatic, they have to be approved. If for some strange reason the trustee wants an increase in pay that is not included in the instrument because the instrument sets a fixed amount, and the trustee feels like, wait a minute, I'm taking on more responsibility for this thing, I need more money, and the beneficiaries and others do not agree, then the trustee is free to go to court and say, based on these things, we feel that our trust income should go from 3 million to 5 million per year. And then the courts will decide if they will approve that or not. And even if the courts approve it, the beneficiaries may still be a little pissed off about that. And get together as a group and say, you know what, let's find another trustee who will take the pay that we want to pay. So even then, thinking that you deserve a higher amount of trustee fees may not necessarily be the prudent thing to do unless you can get agreement from the beneficiaries themselves, because they're usually the biggest problem for any trustee. Okay. So, Lisa, keep going. Trustee Powers. So now we're moving from Trustee Duties to the other side of the fence, which are the Trustee Powers. And you'll see that they are not really the same. Okay, Lisa.
Trustee Powers. The nature of a trust involves the trustee holding the legal interest in the property. The equitable interest in property, the property is held in trust for the beneficiary, its lawful owner. A power is where a person owns both the legal and equitable interest in property. As the absolute owner of the property, the person may do as he wishes with the property and may, in his absolute discretion, transfer all or part of the property to another person. It is important to note that while a trustee may be the legal owner of trust property, he does not have the full powers of a legal owner of property as recognized in law. Trustees may exercise such powers given to them in the trust deed, under the Trustee Act, or under the general law. Recall that a power is discretionary and a duty is mandatory. In the absence of bad faith, a court will not interfere with the trustee's exercise of his discretion. A trustee will also not be compelled to exercise his fiduciary powers, even though he has a duty to exercise such power. The distinction between a trust and a power placed in a trust was outlined in the case of McPhail versus Stoughton, 1971. The powers of a trustee by statute are set out in the parts 2, 3, and 4 of the Trustee Act. Some of the main powers are power of investment, power to retain investment, power of sale, power to insure, power to compound liabilities and settle claims, power of maintenance, power of advancement, power to concur with others, power to employ agents, and power to apply to the court. Within a trustee's fiduciary power is the duty to consider whether to distribute income or capital, although he is not under a duty to actually distribute. Turner versus Turner, 1984. Generally, a trustee must consider whether and how he ought to exercise his fiduciary power as stipulated in the case of Retirement Pensions Trustees Limited versus Evans, 1991.
Thank you, Valisa. So she's already said a mouthful, especially when we got to all those powers. How many roughly? About 10 of them again. And as you can see, these powers give the trustee a lot of power, obviously, but as usual with a lot of power comes a lot of responsibility, okay? And interestingly enough, these powers include things like power to compound liabilities and settle claims. That means that the trust can incur liabilities and have claims to be settled, and the trustee has to make a decision about how to deal with that. Power of maintenance. If a trustee is holding real estate in trust for the beneficiaries, the trustee has the power to determine how the property is going to be maintained. Or if there's a minor who needs to be looked after, that comes under the power of maintenance. If there's an incapacitated person who's a beneficiary, that comes under power of maintenance. How do we maintain and make provisions for them? Okay. So a lot of power issues coming up with regards to the trustee's responsibility. Okay. The power to confer with others on any issues that will allow the trustee to do the job better. The power to employ agents to get the job done, other professionals. Okay. And last but not least, the power to apply to the court. So any matters that are concerned that the trustee has whatsoever, including matters relating to beneficiaries, protectors, and others, the trustee has the power to apply to the court to get some result that hopes will be in its interest. Big job for the trustee from the very beginning. Okay? And the idea is to make it clear to all of us who are in the trust world, understand clearly the huge responsibility that exists with the trustee, whether you're an individual or professional, and all the persons and players involved in the trustee process. Okay? All right. Notice the reference to the various cases. Again, you don't need to learn the cases in detail, just look at them and see if the basic content confers with the information. Okay. All right, thank you, Melissa. Who's next on my list? Leah, are you there?
Yes, I am.
Okay, Leah, why don't you start with under trust law?
Sure. Under trust law, a trustee is mandated to exercise his powers to distribute trust property in accordance with the provisions of the trust instrument. As a corollary of this principle, the discretion to exercise such powers must be done honestly, fairly, and in good faith. The trustee must always keep in mind the goals of the trustee, which are primarily to protect and preserve trust property on behalf of the beneficiaries. Once the trustee acts in good faith in exercising his powers of discretion regarding the distribution of trust property, he will be protected by law, particularly if he has done so according to the terms of the trust instrument and as permitted by law. The Trustee Act 1998 gives trustees the power to insure themselves and their employees against personal liability and pay insurance premiums from the trust fund, except for breach of trust. Additional powers conferred by sections 14 to 31 of the Trust Act, unless some contrary provision exists in the trust instrument. The trustee's powers may be restricted or increased by the provisions of the trust instrument. Notwithstanding this fact and the fact that a trustee's powers may be expanded by the Trustee Act, And the Trustee Amendment Act 2011, a trustee should ensure that the trust instrument provides sufficiently for his powers so that he is able to discharge his duties and responsibilities efficiently and effectively. More specifically, trustees real property and also have power to borrow trust funds in certain specified circumstances. A trustee's power of discretion may be used in many ways to protect a beneficiary, including the power to withhold income payments to a beneficiary and apply these payments otherwise, particularly where such payments may be claimed by the beneficiary's creditors. A trustee may also make distributions to the beneficiary under certain conditions in order to protect the trust property from being dissipated. Trustee minutes are often used to document the reasons and discussions made by a trust committee for a professional trustee's discretion in the exercise of its discretionary powers. These minutes are protected from disclosure under the Trustee Act as they are not considered trust property subject to the beneficiary's right to information and access.
Okay, thank you, Leah. Fantastic. Ready, believe it or not, in that big huff and puff, you said a lot of things about the powers of the trustee. And clearly, the trustee has to make sure that these powers are understood and they are adhered to, for sure. Okay? This power to distribute trust property in accordance with the instrument, it's pretty much self-explanatory, but believe it or not, in practice, it is violated often for one reason or another. We are reminded again that the discretion to exercise power doesn't mean that you can act indiscreetly. The more discretion you have, the more honest and fair you're expected to be. Just like if you work for a company and one day the boss gives you the keys to the business, that does not mean that that is your right to do anything you feel like, including the wrong stuff. Once you get those keys, that means you're expected to act even more responsibly than before, because in a way, you're taking on a greater trusteeship by receiving the keys to that company. Same kind of principle, okay? So the more discretion you have as a trustee, there's more room to do the wrong thing. That's why we emphasize that our discretion must always see us doing the honest and fair thing on behalf of beneficiaries. Always. Always seek to protect and preserve their trust assets and to do what is right for them. Doesn't matter if you agree with it, doesn't matter if you like them or not, has nothing to do with that. It has to do with your professional responsibility as a trustee. Okay? All right. Then we talk a little bit about the Trustee Act. If you haven't looked at it yet, those referenced areas, take a look. Trustee Act 1998 and as amended 2011, etc. Look at those sections and see if it's true. See if these powers are conferred, that they do exist. Because remember, for you guys who are in the trustee business, your most important document is the trust instrument. And the reason why, if you try to go to court before consulting the document, the first thing the judge will ask you is, have you consulted the trust instrument? And if you said, well, not really, we just thought it would come to you, then the court, even in its wisdom, will refer you to the trust instrument, because the court understands that that is the first line of defense. Go there, see what it says. If the trust instrument doesn't satisfy the trustee, then the trustee may go to the what? Trust law, 1998, the Trustee Act, to see if the act make any provisions for what they would like to do or what they're currently doing. And if the act does not provide the provision or is not clear, then as a last resort, the trustee is free to approach the court and say, we have consulted the instrument, we have consulted the Trustee Act of 1998 and its amendments, and we do not see where it makes any provisions for this, but this is what we'd like to do. The courts will then look at it and take a decision, and of course, the decision of the courts is final. but that's how things ought to work in the world of trust, okay? Especially when there's a dispute or the trustee wants to take a certain action that may not be satisfactory to the beneficiary or some other persons or agents. Okay? Distributions to beneficiaries. What can I say? This is always a major bone of contention. This distribution typically has to do with money. And every year, typically, trustees are distributing monies to beneficiaries all over the world. Money is not the only thing. It's just one of the major distribution areas that goes out directly to beneficiaries year over year, as instructed by the instrument or otherwise, the discretion of the trustee. And so those beneficiaries who are waiting to get their hundreds, thousands, and millions every year, they are waiting anxiously each year to see if they get the correct amount, the right amount, a satisfactory amount, etc. And so every year for trustees, the distribution of money in particular to beneficiaries is always an interesting time. Some beneficiaries are happy with what they get, others are not, and others are so unhappy that sometimes it even ends up in the courts. Okay? All right. And who will take us to the end? Ironique, are you in the class yet? Pepin? Okay, Melissa, why don't you take us to the end of this unit then, beginning with regard. Melissa? Melissa must have run off for a cup of coffee. Janice, are you there?
Yes, I am.
Fantastic. Okay, Janice, why don't you take us to the end then with regard to?
With regard to the delegation of trustee powers, the general principle is that a trustee cannot delegate his power as to whom and to what extent trust property may be distributed. However, a trustee may delegate certain duties and tasks in the administration of trust that may contribute to the exercise of a trustee's powers in the distribution of trust property. A trustee's power or discretion must be a positive mental act and must not result from his omission of or inaction. Additionally, trustees are not compelled to give reasons for the decisions, particularly to the beneficiaries. A trustee must take particular care that his powers are exercised honestly. Otherwise, any dishonest or improper exercise of his powers would invalidate it and any distribution made to the beneficiaries, depending upon the facts in the case. Equally important is the fact that trustees must exercise their discretion within a reasonable time, which again depends upon the facts of every case. Other circumstances regarding the time and type of the exercise of power of discretion may determine whether it will be validated or not. The exercise of a trustee's discretion must be done fairly and independently, and a trustee must not be seen as a nominee of the settlor or a puppet on a string.
Right.
Should the
Keep going.
Should the trustee act solely and exclusively by the instructions of the settlor and not act independently, the trust may be declared a sham in many offshore jurisdictions, particularly in the instances where revocable trusts exist and give the settlor very wide powers to control and dictate the trustees and the trust.
Thank you very much, Janice. And believe it or not, in those 1, 2, 3 paragraphs, 4 paragraphs or so, you have no idea what a can of worms you just opened up in there with regards to trusteeships. Okay. We mentioned the issue of the delegation of trustee powers briefly before. Now it has come up again. Okay. And we are told that the general principle is that trustees cannot delegate their powers in any wishy-washy way. In fact, they cannot delegate them at all. They can delegate responsibilities, but not their power. At the end of the day, whomever they give work to, or give assignments to, or outsource it to, or act as agent on behalf of the trust, at the end of the day, the trustee is still responsible for the results. Okay, for sure. A long time ago, and somewhere something went down, and somebody said to me, they said, "Oh, Mr. Wilkinson, something's come up, and we need you to respond." And I said, "Okay, and why do you need me to respond?" They said, "Well, you are the person responsible for this in the household, and therefore you are required to respond." Now, in their opinion, I was like a trustee for that matter. And so they're asking me to respond. As a result, I couldn't say, "Well, what about Mrs. Wilkinson? Or how about Samuel Jr.? My baby Dante, why won't they respond?" The point is, whatever it is, they decided that I was like the trustee. And so I was the one who had to take responsibility for that particular situation. And trustees are like that. Okay? You can help anybody, any agent, any person, any company, any professional, anybody help and provide information for the trust. But if whether it goes right or wrong, the trustee has to take responsibility. Now, if the trustee loses money in the process, the trustee may subsequently sue the agent or whoever provides the service. However, as far as the beneficiary is concerned, they don't want to hear the trustee say the agent is responsible. They want to hear the trustee say the trust is responsible, and we will take whatever action is necessary to resolve it. Because as your trustee, I realize that one of my duties, powers, is that I'm responsible. We are responsible for this issue. Okay? Simple as that. So yeah, you can delegate duties and tasks, etc., but you cannot renege on your responsibility. Period. Okay? Notice we are told, interestingly enough, that a trustee's power or discretion must be a positive mental act. I wonder, who knows, what do you think we mean by that? It must be a positive mental act. What do you think that means? Doesn't mean anything at all? Well, what it means is that whatever the trustee decides to do, it must be a very conscious decision. Okay? There must be no deliberate effort to leave anything out. There must be no deliberate effort to not act. The trustee must always act, and the trustee must always not leave anything out that's important. That's what a positive mental act is all about. Okay? Now, interestingly enough, when trustees make decisions in their discretion, the law typically does not require them to give reasons for their decisions or their discretions, particularly to beneficiaries. That has always been a bone of contention, and it's a bigger bone of contention in the 21st century, more so than ever before. Because oftentimes when trustees make decisions in their discretion, beneficiaries want to know why. The trustee is not required to give a reason to the beneficiaries by law. Usually, if it's a discretionary trust, the trust instrument allows that the trustee does not have to give an explanation. Sometimes beneficiaries sue because they want an explanation, and the courts will usually honor the trustee's decision for not having to disclose their reasons to the beneficiary, unless it's a very peculiar case. And those cases are normally dealt with on an exception basis. But as a general rule, the trustee is not compelled. That's the point to underline. Not compelled to give reasons for their decisions to the beneficiary. Trustees are encouraged to write their reasons down in a memo for future reference in case they need it, but this information does not have to be given to beneficiaries, even though beneficiaries are constantly seeking it. Okay?
Who would they give this to? I mean, what's the point? Who would they tell it to if need be?
You mean
their reason? I mean,
they don't have to really tell anybody. That's the crazy thing. For example,
okay.
A lot of big firms, trust companies have trust committees. Okay, instead of just one trust administrator, they have a committee that make decisions on these distributions, etc., and the reasons that they come up with for these distributions. And so if it's one administrator making the decision or a committee, none of them are required in law, and usually oftentimes by the trust instrument, especially if it's a discretionary trust, to give a reason. And one of the reasons for that is oftentimes if the trustee is made to give a reason or tries to give a reason, it always creates conflict with one beneficiary or another. And so the law respects the fact that the discretion can be made as long as it's prudent and fair, can be made without giving a reason to the beneficiaries. And the question you raised was a good one because it happens all the time, even as we speak. Then who do they give it to? And beneficiaries have that same mindset, like, you can't tell us the beneficiaries, then who the hell do you tell it to? And the answer is no one, only the trustee. Okay? It's like the Pope who only tells you what he wants to and keeps the rest to the Pope. I'm the Pope. I have the discretion to keep what I want to keep, so to speak. Okay?
I have a question,
yes.
Just continuing on from that. So in a situation where a beneficiary might go to court to try to say that a decision was made and it wasn't made fairly, would the court maybe then ask for proof as to why it was made, the decision was made the way it was made?
Absolutely, the court may.
Okay.
If the beneficiary takes it to court with a compelling reason for wanting a reason, see my point? Like they believe the trustee is taking a personal approach towards them or has some kind of personal beef with them or some such thing, if they can make a compelling case to the court, yeah, the court might say to the trustee, we need you to tell us what your reason is, which is one of the reasons why it's a good idea for the trustee to what? Minute their reason, even though they don't have to give it to anyone. You follow? Because they may have to go back and reference that if the matter gets to court. Because if they don't write it down, they may not remember why they didn't. And that could be a problem. So the courts, yeah, the courts can compel the trustee, like, what was your reason, Mr. Trustee? And then the trustee would have to tell the judge. Then the judge, in his wisdom, how about that, will say, okay, that's a reasonable reason for not disclosing. Or, hell no. In this particular circumstance, even though we know that typically you don't have to disclose, in this case, it is such a grievous matter or egregious matter that we need you to disclose it. And that would normally be done on an exception basis, okay? Which is why oftentimes when these things come up, beneficiaries tend to take it to court to see if they can get a decision that is not consistent with the normal requirement, which in this case, the trustee does not have to disclose his reasons to the beneficiary for his decisions. Okay? That's a good question. And oftentimes these matters are taken to court in order to get a reason. Okay? And every blue moon, they get a reason, but not too often. Okay? Again, we're back to the trustee must take care to exercise powers honestly, again, because if you don't, any dishonest or improper exercise of this power will invalidate, see that word? So for example, let's say a trustee made in his discretion, because it's a discretionary trust, to give one beneficiary $5 million and another beneficiary $1 million. And the one who gets 1 million somehow finds out the other one got 5 million. Then the one who got 1 million might contest it. Okay, and so I don't think the trustee acted honestly. I think they give that one 5 million because they like that one. I think they give that one 5 million because maybe they have an affair going on, because I saw them all snatched up and cozy somewhere in one of the expensive restaurants in Nassau or somewhere in the world. Whatever the reason. And if it is discovered that that may have influenced the distribution of the assets in that particular year, or if it was distributed for some dishonest or improper reason, then the courts might change that position and rule against the trustee, and even find the trustee to be in breach of trust, but potentially by doing that. And the reason would probably be indiscreet exercise of your discretion, Mr. Trustee. You can't have a relationship with one of the beneficiaries and then in your discretion give that one more money one year than the other one without being able to justify it any other way. These things happen, okay, in the real world, actually. All right. So this stuff is very important that the trustee understand their responsibilities in this area, and that's why it keeps coming up. Interestingly enough, in the paragraph before the last, we have this expression, equally important. See? Equal to what? Equal to proper discretion being exercised. That's what, in the previous paragraph. Equally important is the point that the trustee must exercise the discretion within a what? Reasonable time. So you can't take your own sweet time to distribute. If you normally distribute to beneficiaries annually a certain amount of money, and you decide, well, I don't like that one, I'll send their own late, like 3 months later, and make them miserable. Well, you might do that, but don't be surprised if you don't come under fire and you can be sued. For what? Not using your discretion within a reasonable time to distribute. That happens. And each case is unique and each case is different. Believe it or not, that happens. Not all trustees always act prudently. That's why it's there. A lot of professional trustees and others are very imprudent, unfair, inequitable in what they do, especially those who exercise what? Discretionary trusts. They start feeling like God with the trust, like I'm God. I'll distribute how I want, to whom I want, and whenever I feel like it. Believe it or not. They may not use those words, but their behavior suggests those words. And so this information is here to remind them and to remind those of you coming on board eventually or already on board of what the duties and responsibilities really are and the powers really are. Not what is actually done, because sometimes what is actually done is not really correct. It's just that trust companies get into that mode, people get into that mode, people get come to it, relationships establish it and support it, and you might even think it's the correct thing to do. When in fact, you might discover, if you're prudent enough and inquisitive enough, that some of the things that they're doing are inconsistent with the requirements of the trust. But that's a whole other ballgame. Okay? We'll assume that they're doing it correctly unless we find out otherwise. But you can see the information is very clear on how it should be done. Okay? And if you're found to be exercising your discretion imprudently, the courts might even reverse your distribution decisions. If you send 10 million to 5 million to someone, and it was discovered that you did it imprudently for the wrong reasons, the trustee might be asked to get some or all of it back and put it back into the assets and distribute what should have been the correct amount, quote unquote. Okay, so the courts can actually invalidate discretionary distribution and change the decision as a result of the action that was brought before the courts. And the whole exercise is a stinky one. And at the end of the day, lawyers get very rich in court fighting this thing. And if the trust is found to have acted inappropriately, then the trust itself would have to cover the legal fees. Not the trust. The trustee himself will have to cover the legal fees, not the trust, which is another issue. Depending on how big it is, legal fees could go into the millions of dollars. That's the other problem. So these things are very serious. A lot of them are not just itsy bitsy stuff for a few $1,000s. Okay. And then finally, again, even in the last paragraph, we are reminded, and it reaffirms, that if you are operating a discretionary trust, your discretion, see, discretionary means you can basically do whatever you want. And then human nature being what it is, whenever we have our discretion, we have to be very special people to act properly. Because if we're not special people doing things, who want to do it right, we start doing all kinds of crazy stuff. Trustees are no different who have discretionary trusts. Okay? That's why, again, in this last paragraph, Mr. Trustee, and of course, Mr. Trustee means Mr. or Miss or Mrs., male or female, doesn't matter who the trustee is. And oftentimes, when we say the trustee, we're talking about the entity, not a person. If we're talking about an individual trustee, then we're talking about male or female trustee. But if we're talking about entity, we're not talking about male or female individual trustee. We're talking about a professional trustee operating through a company or an entity. Okay? In any event, if you have a discretionary trust in your portfolio, and there are many of them, most trusteeships are discretionary compared to non-discretionary. Okay? Your discretion must be fair and independent, meaning no beneficiary, no family member, no drinking buddies, no QCs, no politicians, nobody should be allowed to impede your independence as a trustee or influence you as a trustee in any way. And that includes the set law. Because some set laws settle a trust, and still behind the scene, they are manipulating the trustee for one reason or another, and some trustees allow them to do it. Because sometimes set laws even threaten trustees and say, if you don't allow me to manipulate you from behind the scene, even though I've already made you trustee and turn my assets over to you, I'll just have a discussion with some of the beneficiaries and have them remove the trust from your portfolio and take it somewhere else where they'll let me do what I want, even though I have no right to do it anymore. How about that? And that's why we say, if the trustee finds himself being influenced too much by the set law, a beneficiary might pick it up and make a claim before the courts that the trust is a sham and have the trust disbanded or removed from the trustee, such that the settler can be directed that you are no longer responsible for these assets, Mr. Settler. Get the hell off the ship and let the trustee do its work. But some settlers, even after they've turned over the assets, they're not happy with just letting it go. They want to say who the trustee should invest with the assets, what the trustee should do, who the trustee should distribute in their discretion to, and so on. In other words, they are involved with the trust to an extent where they shouldn't be. And in most offshore jurisdictions, as we are told, this is considered to be a sham, and one of two things can happen. The whole trust can be disbanded to be started over again and put to right, or the trust itself, trustee might lose that particular account. It goes somewhere else where the settlor cannot exhibit any influence over the trustee. Okay? Which brings me to my final point. Just though we have this discretionary and non-discretionary trusts, we also have revocable and irrevocable trusts. Have you ever heard about that? Those two? Revocable and irrevocable.
Yes.
Yeah. Make sure you know the difference. For those of you who may have not ever heard it, if a trust is revocable, it means that anytime in the future, the settlor can go to the trustee and say, I want my assets back. And that would be in the trust instrument. That would be considered a revocable trust. If a trust is irrevocable, it means that once that is concluded, the settlor can never go back and say to the trustees, I want my assets back. Because they'll never get it back and no court will approve it. And if a court does, I can't even think of a reason. They might have to give a reason like the trustee is totally incompetent, a former bankrupt, discharged, a former thief, or some egregious situation to cause the courts to say, okay, fine, give the guy's assets back. But typically it never happens if it's an irrevocable trust. Okay? All right. So I think I bombarded you with enough stuff for today to think about. What I would like for you to do, has anybody attempt to do the questions at the end of Unit 6?
Not yet.
Not yet. Okay, that's fine. What I would like for you to do for next Saturday's session is go ahead and answer the questions in Unit 6. Before we begin our discussions next week, we'll go over those questions to see what you came up with. And then please read Unit 7 and 8 for next week's session so that when we come back, we jump right into it and see what's going on. Okay? Any other questions before we break?
Can you say what the name of those chapters is so that I could follow, because my one is labeled differently?
Okay. Thank you, Melissa. Let me see if your colleague, I can say it. I just want to test your colleagues to see if they're on the same page. Can anybody tell Melissa what the other topics are, the next three?
Sure. Unit 7 is trustee remuneration. And 8 is retirement and removal of trustees.
Thank you.
You're welcome.
And number 9?
Sorry, let me look. Number 9 is the role and responsibilities of the trust administrator.
Okay, got that, Melissa?
Yeah. Yes, thank you.
Okay, so Leah.
Yes, sir.
I see you are multitasking.
I am, yes. Just recently in the last 10 minutes.
No problem. I don't mind that. I get it. When my babies were born 1,000,000 years ago, every day I'd look in the crib and it looks like they're not growing. And then when they turned 1, it looks like they're not growing. And then when they got in grade 1, it looks like they'll never leave grade school and so on. And guess what? They're all men. And sometimes I wish I had my babies back in my arms, taking them to preschool and so on. So I say that only to say it's perfectly all right. Enjoy it. Because the time, take my word for it, passes all too quickly. Okay?
I will, I know. And the funniest thing is she's my godchild. I don't have children of my own, but she's just like my child.
I get it completely. The same principle applies. And you'll find that whenever you have children of your own, even more so. Okay? But she'll give you an idea of how it goes. When you have your own, then you have the real bloody McCoy. Because you can take godchildren back to there.
Yeah, send them back all the time.
Yeah, but if it's your own, you can't send them anywhere. In fact, if you try to send them, you say, no, I'm busy. You better keep your own children, or whatever the case might be. But yeah, okay? No problem at all. All right, so if there are no other questions, any other questions before we break? Fantastic. If you think of anything that you want to raise from this first unit, please make a note of it for next class. If you have any situation on the job, any issues you want to present without indicting anybody, please feel free to present them. Anything you say, I guarantee you will be helpful to your colleagues in the classroom. Otherwise, go ahead and do the responses for Unit 6. And if you feel really, really great, go ahead and do the responses for Unit 7. And then next week, we'll cover Unit 6 questions. Then we'll get right into 7 and 8 discussions and maybe the questions for Unit 7 and forge ahead. All right? In the meantime, if there are no other pressing questions at the moment, you guys be safe and be careful. I'll see you next week, Saturday, same time, to tackle the other interesting issues in trust. Okay?
Thank you.
Okay.
Bye, everyone.
Bye.
Good night.
Take care, everybody. Be safe out
Bye.
there. Bye-bye.